Good afternoon. Thank you for joining Prime Capital Retirement for our quarterly ERISA attorney talk. To start the session here today, I want to call attention to a change in brand. You have known us over the past number of years as qualified plan advisors, and we recently started the process of changing to Prime Capital Retirement. My name is Mike Smoots. I'll be your moderator for today, and I'm joined by Chuck Smith and Scott Liggett and Matthew Eichmann. And Chuck, I know the rebrand was near and dear to you. I didn't know if you wanted to share a comment on that.
No, I think this is a positive step for all involved. There's been a lot of confusion, I think, as we know, dealing with clients about Prime Capital, which is our mothership, and branding it as qualified plan advisors. But I've labeled it as simply, we're like X, formerly known as Twitter. So we are now Prime Capital Retirement, formerly known as qualified plan advisors, although obviously it's going to take a long time for us to stop saying that and get used to saying Prime Capital Retirement.
Yeah, so the brand will be faded over time. Folks will continue to see references to qualified plan advisors, whether intentional or unintentional, but on a go-forward basis, you'll see Prime Capital Retirement increasingly, and then relative to our participant focus, that will be referred to most generally as Prime Capital Wellness, as I believe. Chuck, thanks for joining us today. You're our retirement leader in Nebraska. I'm also joined today by Scott Liggett, who is our Director of ERISA Oversight. And I also want to call attention to Matthew Eichmann joining us today. Matthew has recently transitioned to become the Chief Legal Officer at the Fiduciary Law Center. In part, I'll let Matthew certainly speak for himself in that regard, but with the continued class action litigation in the space and the importance of having that third-party neutral, Matthew will bring to us a perspective that's not just focused on our own clients. Matthew, did you want to say anything further about that?
No, just thanks for having me. It's good to be back with the group again, and I'm looking forward to hearing from all of you.
Great, thank you. So the topics that we're going to address today, Scott Liggett will kick us off here with an update on Secure Act 2.0 specific to these optional provisions, withdrawals, and distributions. Then we'll transition over to Chuck, who will talk with us about super catch-ups and a little bit of a wrinkle as to the ages that applies to. Secure Act 2.0 also made available this portability design, and a number of record keepers have opted into that, and he'll explain that to us. I'm going to share a little bit with you about the recent class action litigation that's really kind of mushroomed again, starting back in September on the use of forfeitures. And then we'll close things out with we'll hear from Matthew on fiduciary hot topics, and then we'll have a little bit of a grab bag to the extent time permits, including this regulatory shift across the country based upon the overturning of the Chevron litigation. So that's kind of our roadmap. Those are the commentators here today. And without any further ado, Mr. Liggett, would you walk us through these optional provisions in Secure Act 2.0?
Sure, thanks, Mike, and hello, everyone. We wanted to start with these newer optional withdrawal and distribution features that were brought into law by the Secure 2.0. And a lot of people may think, that was over 18 months ago that the president signed Secure 2.0, and a lot has happened since then. Most record keepers and administrators first had to deal with the mandatory provisions, and those were what took up most of the time in 2024. And as we've now shifted to these optional provisions, we wanted to group some together here, including these withdrawal and distribution. So we have some information here about a new withdrawal for emergency expense feature. There's also new eligible distributions for domestic abuse victims, withdrawals for federally declared disasters, and then lastly, sort of a modification of Secure 1.0 with what was brought into clarification by Secure 2.0. And at the bottom of the slide, I talk about the commonality here. It's a pretty important distinction. And for each of these types of withdrawals, they are an exception to the 10% excise tax or early withdrawal penalty that apply to most and have historically applied to any early distribution or withdrawal prior to age 59 and a half. So they're unique in that fashion. And then each of these also have a pretty important distinction in that these withdrawals can be recontributed or repaid back. And if you think about it, historically, we've had hardship withdrawals, which most plan sponsors have worked with in the past. And once that money is taken out of the plan, there's no mechanism to put it back or to repay. So we're used to that format. We've also been used to 401k loans, which have an amortization schedule, repaid through payroll deduction. And we're that's a very common practice. So these 4 types of distributions all are unique in this, the ability for the participant, if they choose, to repay them. So the next few slides, real quickly, this is one I'll just spend a minute on because this is one I get probably the most questions about. And this is withdrawals for emergency expenses. And, with hardship withdrawals, you've always had to meet the participant had to meet the IRS criteria for what met the definition of a hardship withdrawal. And whether it's, inflationary pressures or just, kind of where we're at with participants in their lifestyle and where they're at, with their money, we've seen an uptick in loans. We've seen an uptick in hardship distributions. And so what this does is allows a participant once a year to withdraw $1,000 or their vested account balance in excess, the lesser of $1,000 or their vested balance in excess of $1,000. And they can do that once a year, provided that they repay that distribution or withdrawal. If they don't repay it, then they have to wait 3 years. So this one I'm getting probably the most questions about. It's not to be confused. Some people have asked, is this the sidecar savings account? And it's not. This is I think is a much more straightforward approach. Then the next type is what we touched on, the domestic abuse victims distribution. The criteria is set out there. I highlighted that, you will need to take note if you have an older plan or have an older provision, particularly with money purchase plans. If the plan requires spousal consent for the distribution, then this type of option may not be available. But again, we go through the criteria there. So the next type that we touch on is for federally declared disasters. If FEMA has declared a geographic area to be a disaster area, then participants have access to their accounts. And this is really a clarification. Historically, Department of Labor on a case-by-case basis would do this with, if you think about Hurricane Katrina and some of the other natural disasters and different type of FEMA disasters, and on a case-by-case basis, they would allow these types of withdrawals. And this uniforms it, makes it a very uniform approach. And again, it can be repaid over 3 years. And then lastly, the one we highlight is this, QBOD. We're an industry that loves acronyms, repayment of qualified birth and adoption distributions. And this is really a clarification, as I mentioned earlier, from Secure 1.0, which made these new types of withdrawals available for up to $5,000 per child. And at that time, the provisions allowed for it to be repaid back to the plan, and Secure 2.0 clarified how that repayment can be made, and it needs to be done within 3 years. So that what happened in practice, in the highlighted language there, you'll see many plan sponsors had held off adopting this type of provision until it was clarified how the repayments would work and what the time frame was. So those are the 4 optional provisions that you may have gotten some information about before. So the question always comes up, what should you be doing as a plan sponsor? And, these are all optional, and you can look at them separately. It's not an all or nothing decision. Your record keeper may have put all 4 together, in some sort of notification to you or newsletter or email to you, but they're not an all or nothing. You want to look at them one by one. And as I mentioned, I've gotten quite a few questions.
Hey, Scott.
Yes.
Yeah, I was just curious. So it's not all or nothing. So there's those 4 new options. I think a lot of people would want to know, like, what are other plan sponsors doing? What are you seeing when you talk to your clients about the adoption of those 4 different distribution options?
Well, it's unique to your organization. No 2 groups are necessarily alike. A number of my clients are taking somewhat of a wait and see attitude, primarily due to the 3rd bullet point there, which is how will the repayment or recontribution factor work? Who's responsible for tracking what? And so I have a number of clients that are waiting to see, and that's the type of questions. I've had a lot of interest in the $1,000 feature and the domestic abuse for victims of domestic abuse. But what about you, Mike or Matthew, or what are you all seeing?
Scott, I'll respond to that. Many of my clients don't allow loans. They do permit hardships. Most of them that permit hardships have been gravitating toward adopting this self-certification feature so that the HR director no longer has to approve the hardship nor keep the documentation. I believe, it's my sense at least, that is a delegation of a fiduciary duty. Pretty comfortable having the record keeper take on that role. Relative to the emergency withdrawals, as you've mentioned, that's a self-certification. So if client has already moved to the self-certification of hardships, they've been inclined, especially if they don't permit loans, they've been inclined to adopt this feature as the record keeper is making that available. Again, the cap being at 1,000, and probably much better, even though we don't want to use the 401k as a piggy bank, probably much better to use those proceeds than to go get a payday loan or put it on a credit card with the high interest rates that credit cards are charging right now.
Yeah, and I think as we close out this slide, be sure to talk with your advisor and your record keeper. Make sure your questions get answered, and that you are comfortable and confident about timelines that are involved, about whether you need to opt in or out of these types of provisions. And if you need any help with that, or have questions for any of us on the panel today, please let us know, and we'll help walk you through those things. And with that, I'll turn it over to Chuck to talk about super catch-ups.
Yes, super catch-up. So as Scott mentioned, those 4 distribution options are optional, and so we're seeing various levels of uptake on that. But I wanted to highlight something that, well, perhaps still optional, is probably going to impact almost all, if not all, of the plan sponsors on this call. So before I get into what the super catch-up is, I'll start with who is eligible for the super catch-up contribution, which, to back up, a catch-up contribution traditionally has been for anyone who's over age 50, they got to make an additional deferral contribution into the retirement plan. For this year, it's $7,500. But now we have this new super catch-up contribution, which will allow for additional contributions for those participants age 60 or 63, or who turn 60 to 63 throughout the upcoming plan year. And you might ask, why did they stop at age 63 and not extend this? Seems like an arbitrary number. And really, it goes back to the Secure Act. It was a revenue neutral act. And so there were a lot of giveaways that Congress was making in there as far as, credits for startup plans. And so they're limited amount of additional giveaways they could give. And when they ran the numbers, when the Office of Management and Budget ran the numbers, they could only provide additional catch-up contributions for this 4-year window. Obviously, it would have been cleaner if they could at least made it up to 65, a nice even number, normally a normal retirement age, but we are stuck with just these 4 years, 60 to 63. And what's the amount of this super catch-up? In the statute, it's a little bit convoluted, and there actually may even be a typo in there that needs to be corrected, but it's generally the greater of $10,000, or, and this is more important, the 150% of the regular catch-up contribution. So it's not affected, it's not effective this year, but next year, when presumably the catch-up contribution goes up to maybe $8,000, we'll have a nice even number that this, the super catch-up will be up to $12,000. So how would this work using 2024 limits? Again, I don't want to guess that that's what the catch-up contribution is going to be next year, but it really makes this checkerboard of different deferral amounts that people are participants are allowed to put into the retirement plan. From the normal catch-up, or if you're not eligible yet for a catch-up contribution, you're limited to this $23,000. The first 10 years that you're eligible for catch-up would be that additional $7,500, so $30,500. Then it springs forward with the super catch-up to $34,250, and then retreats back to the catch-up amount of $30,500 for those that are above 63, 64, 65, or older.
Chuck, could I ask you who, it's a pretty, there's some narrow bands there. Who, in your discussion with record keepers and your plan sponsors, who's going to keep track of who's become 64 and who is going to become 60 next year? Who's in charge of tracking this?
Yeah, it's really a two-prong approach, not much different than your just normal catch-up contributions, just a little bit more complicated. If you're using a payroll company, they're going to handle it on the front end. They're working diligently, but check with your payroll provider to make sure that they're going to be ready by January 1 of next year to have these different amounts so that people don't over contribute. If you're not using a payroll provider, then this is going to fall initially on the plan sponsor and your HR and your compensation group to put all these parameters in and have these 4 different brackets, again, going from 2 brackets to 4. And then on the back end, the record keepers will also be tracking this, but of course they're doing it at the end of the year typically. So if your systems aren't built in place when someone turns 64 and they're still allowed to put in that $34,250, then they're going to get a refund after the end of the year when your record keeper finally puts it together and says, oh, that person was not eligible for the super catch-up. They aged out of it. So some additional legwork that you want to make sure your payroll provider is doing, or your internal payroll team is doing to make sure that these are ready for 2025. So I gave that away. What's the effective date? It's the first plan year beginning after January 1. So for most plans that are on a plan year, this will go into effect on January 1 of 2025. One of the questions that was immediately raised is, if you recall, it seems like a distant memory, but just a year ago, there was a lot of fretting about that catch-up contributions were going to have to be made in the form of Roth for anyone who made $145,000 or more. Well, that's still true for the super catch-ups as well. So if you recall, that rule was pushed back by the IRS. They weren't going to enforce it because of all the difficulties from record keepers and payroll providers implementing it. So that was pushed back to 2026. But that super catch-up that is made in 2026 for anyone over $145,000 will have to be Roth. So again, we get this whole nother challenge of tracking year by year that right now we don't have super catch-ups. Next year, we're going to have super catch-ups and they can all be pre-tax. But then in 2026, we're going to have super catch-ups, but it's possible for a lot of those individuals, it's going to have to be in the form of Roth. So it's a logistics, gymnastics to try to figure out exactly how much those are and what form the contributions can take. Which brings up another question that's kind of a hot button item: is, are super catch-up contributions required? What if I don't want to deal with that with the 4 different brackets of age groups? And it is not required. However, most record keepers are making it the default. So you would actually have to opt out of this or catch-up contributions to not have to administer a super catch-up contribution. Scott, any input on or any thoughts on the requirement that it's, or whether it's catch-up, that the catch-up is required?
I had this very discussion, I was mentioning, and Chuck had this discussion with the record keeper this morning, and they are They're one of the larger ones, and they are going to default all of their plans into the super catch-up. The plan sponsor will have the option in writing to opt out of that. But so again, this and just a comment, this is a provision unlike the optional provisions, as you mentioned, which there's no rush to do it. Here I think plan sponsors need to get their arms around it and get comfortable and confident about what their record keeper is or is not doing with this, because it does go into effect next year. And so I find this one is kind of in the shadows, not being brought up as much as it probably needs to be.
Absolutely. And if anyone on the call gets pushback from their record keeper that it is required, reach out to their advisor. They can put you in touch with one of us. That it is not required. If you read the statute, literally it is not. However, keep in mind from a practical standpoint, just like a normal catch-up contribution legally you don't have to make a $7,500 or allow for $7,500 catch-up, but practically speaking, it's a box on an adoption agreement. And so you're electing to add catch-up contributions, and your record keeper's adoption agreement may be written the same way. And so if you elect catch-ups, it's going to be adding the normal catch-up and the super catch-up. And even though you're legally permitted to do it, it may be that it's difficult to get that actually implemented on the adoption agreement or through the record keeper. But reach out to your advisor if that's the case. So turning to a different subject, we've talked about the distribution options that are available in Secure 2.0, plus that additional contribution option. I wanted to touch on another thing that came out of Secure 2.0, and that was the ability to have organizations that run portability networks or that automatically recontribute distributions, force out distributions into another retirement plan. As an advisor, and I'm sure the others on this call can speak to it, oftentimes we're out meeting with employees, and an employee will meet with you and say, I want to roll over the account an amount from my former employer. And we're like, yes, we're super excited to help them. And then it's $2,000. And we'll work with them, but it's a lot of work for a $2,000 rollover. That's why I'm super excited about this Portability Services Network as a methodology to basically automatically take that $2,000 amount that was left at someone's old employer and roll it right into your retirement plan. So this was a provision that was put in Secure 2.0, which basically codified some guidance that had been issued prior to that stated that it would not be a fiduciary breach by a plan sponsor. And they basically created a safe harbor from a plan sponsor to permit their employees to go first into an IRA and then be forced into another retirement plan. So now it's codified. And so this Portability Services Network was all ready to go and was ready to launch as soon as Secure 2.0 came out. And right now there are 6 record keepers who are the owners of this group. Their additional record keepers are welcome to join, but as you can see here, a number of the larger players in the retirement plan space are members of this network, which basically means that if you are with Empower or with Fidelity and you have an employee that terminates employment and you roll that IRA, you roll that distribution out of they're under $7,000 and you force them into an IRA, they will immediately go into their new employer when they are rehired. Or conversely, if you hire an employee, a new employee, it may be that they will automatically bring over with them a rollover of $3,000 or $4,000 that is implemented through this Portability Services Network. So it's good on both ends. It allows for an ease to force participants out, but then it's a way to kickstart a new employee as opposed to automatically enrolling them and they're at 0% or $0 balance and gradually increasing. They may immediately have a $2,000 or $3,000 account balance and give them more of an impetus to even log into your record keeper and get involved with the retirement plan. I'm not going to go through this slide in much detail, but this is the inner workings of how this works. That you basically, as a plan sponsor, you force people out into an IRA. It then briefly goes into this portability IRA, and then is immediately transferred to the new plan once that information is submitted to this group. So it's really a 5-step process, but from your standpoint as a plan sponsor, you'll just force people out like normal if they're under $7,000. And then you'll get money sent to you with a new employee if they have money in one of these automatic portability IRAs.
Hey, Chuck, I've got a question for you.
Sure.
You just mentioned the force out limit at $7,000. Have all of your clients experienced that sort of pop up from 5,000 vis-a-vis the record keepers?
Yeah, so what Mike's referring to is in the Secure 2.0, which again, there were 92 different law changes. One of those was the force out limit went from $5,000 to $7,000 this year. And I had no plan sponsors who did not. The record keepers basically made this a default. So you had to opt out of that to keep it at 5,000. And so all of mine moved to the 7,000. And in fact, I still had some employers who were on the very old that were using a $1,000 cash out limit, because that way, if you're forcing out under $1,000, you wouldn't even have to send it to an IRA. You could just give someone cash. And this was a good opportunity for them to revisit that. And most of those agreed, yeah, let's get an IRA provider and increase the force out limit up to $7,000. And so that's, Mike, exactly what I'm referring to here on this slide, that you may have to amend your plan to provide for force outs. And additionally allow for rollovers and to adopt this auto portability. So some of those are happening by default. The others, allowing for adopting the auto portability is that's going to be a decision that you actually have to make and to amend your plan to allow for that auto portability. The second thing is with anytime you're forcing someone out, as I said, between $1,000 and $7,000, you have to force them out to an IRA. So the rollover IRA must be part of this network. Most of those record keepers that were alluded to here are going to have that provision, but some of them may be switching who their IRA provider is to make sure that they are in this network. If they were using it, just pick one of those record keepers. If they might have been forcing participants into a third-party IRA that is not part of this group, they're going to ask you to amend that so that you are rolling into their rollover IRA just as a conduit until that employee goes into a new employer and can be rolled over. You will have to sign a contract with the auto portability service provider. In there will be a description of the fees. You can walk through those with your advisor. Just make sure that you're comfortable with those. And then finally, you have to update your summary plan description so that you can inform participants that this is what's going to happen because right now it will just say that it's going to go over to an IRA if they are forced out under $7,000, between $1,000 and $7,000. And you'll have to update that summary plan description to give more information about the fact that it will go to an IRA and then could go to another retirement plan. So those are the steps. Hopefully, I'm a big fan of this. I'm hoping that additional record keepers see the value in it and agree to join this network so we can truly have a universal system. I mean, it's a win for everybody. It's a win for the plan sponsors who get these additional flows of money in for new employees. It's a win for record keepers who get to keep assets inside the system. And it's a win for participants because a lot of these participants either go to cash or there's a study just recently that a lot of people go to an IRA, rollover IRA, and they just stay in cash because they're really not that active. And there's for 5, 6, 7 years, they've just been in cash. Well, this will get them back into a new retirement plan invested. So to me, it's a win-win-win. With that, I think that finally sums up all of our Secure 2.0 information. So I'm going to turn it back over to Mike to get into some litigation.
Thanks, Chuck. Looks like we're about at the halfway mark here. So we were having some interesting discussion about this topic before we joined everyone on the call. So I invite you all to interrupt and comment. But the topic here is forfeiture litigation. And forfeitures happen when we have participants who have received a company contribution and they leave the organization before being fully vested in that contribution. It could be a match, could be profit sharing. Traditionally, what's happened with those dollars is the record keeper has sort of sequestered them in a separate account, and plan sponsors have been able to use those dollars to pay plan expenses or to offset the company contribution. Again, could be a profit share, could be a match. Last September, the first litigation that I tracked was against Thermo Fisher Scientific. And it was a class action that alleged that Thermo Fisher had violated its fiduciary duties under ERISA by using plan assets to pay company expenses instead of refunding those monies back to participants. We've since seen a number of other litigations. You can see the logos there below with Clorox and Intel, and I think most recently Wells Fargo. One logo that probably should be on there because it's a little bit more interesting is Qualcomm. And earlier this summer, we saw that Qualcomm litigation, and in the Southern District of California, Qualcomm moved to dismiss the class action, and the district court ruled against the motion to dismiss. The justification by the judge was that the plaintiffs had in fact stated alleged a claim sufficient under ERISA to proceed, that the use of forfeiture dollars to pay plan expenses that the plan sponsor would otherwise cover out of pocket did potentially state a claim that could be recovered upon. So, in my opinion, I just don't think, frankly, under the law, there's this notion that you can argue that the law is in your favor, or we can argue for a good faith expansion of the law. I'm not sure this even falls into that latter category about a good faith expansion of the law, but nevertheless, this is a dynamic environment. And as everyone knows, the class action litigation in the 401k space has become a cottage industry. So yeah, I know I'm jumping around here a little bit. Chuck, if you'd go back to the reg, I'll speak to that and then invite you guys certainly to comment. So we did get a reg from the IRS, and the reg is pretty clear, and I think it's consistent with what has been the past practice, as I mentioned, which is to use forfeiture dollars to pay administrative expenses, to reduce employer contributions, or you can refund those dollars back to participants. There's also been a little bit of a debate as to when those dollars need to be used. And so for a period of time, as I understand it, the IRS was encouraging folks to use them within the plan year that the forfeiture dollars are moved over to the account. And then I think that's been expanded by this reg to that year or the year following, the plan year following the year in which they were forfeited. So we don't have, that's still a proposed reg. We got some comments, but we don't have any action on that reg yet. That is the guidance from the IRS. And so really that does beg the question, and you can see there in the yellow highlighted in accordance with plan terms. So on the next slide, I just cut and paste two provisions from volume submitter documents that address forfeitures. And you can see in the first paragraph, it doesn't exactly mirror the language of the reg, but it's pretty close. And the second from another major provider does the same. You can use forfeitures and you can order it. You know, the second paragraph says first used to pay administrative expenses under the plan if directed by the employer, and then not used to reduce administrative expenses as directed by the employer applied in accordance with that section. So, you know, Matthew, thanks for joining us again today. I think you've got some comments there about those plan terms, and Chuck, your perspective was whether or not a fiduciary breach could even be recovered upon in this regard, or whether that action, that use of forfeiture dollars might kind of fit under the Sepler hat.
Yeah, actually, can I jump in and just ask a
Please.
quick question? So you pointed out this regulation, which seems to be pretty clear from the IRS, that says these are permissible. So people in the audience may be confused about how this lawsuit can proceed when you have a statute, a regulation at least from the IRS, that seems to permit this. Is that not a conflict?
Yeah, and Mike, I can take this one. So Chuck just asked a very critical question. We have a regulation, and we actually have an IRS perspective that we know supports your flexibility to use forfeitures for either administrative expenses or contributions. So that sounds like you have the authority to do whatever you want. Here's the argument that's coming from the plaintiffs in this situation. Yes, it's okay for you to use it for either of those, and you can put that into your plan document. But when the plan document says you can do A or B, when you make a choice, that becomes a fiduciary interpretation of your plan document. And if you as a fiduciary choose the option that offsets employer contributions, instead of the option that would reduce expenses to your participants, you've made a decision that helps the company but doesn't help the participants, and in doing so, you have breached your fiduciary duty of loyalty. That's a lot of words to respond to that, but that's really what we're seeing here is this idea that, sure, both of these are okay. With that said, when the document gives you the discretion to choose between one or the other, if you choose the one that benefits the company, the argument in these lawsuits says that by doing so, you've breached your fiduciary responsibility. Chuck, do you have any thoughts in response to that?
Yeah, I'll ask another question then. Just to be the devil's advocate, like in this second provision here, it says if so directed by the employer. Now, that seems like it's not saying plan administrator, it's saying the employer, which we've always been taught, the employer is a settler. So maybe you can expand on what the court opinion of that was.
Yeah, and Chuck's brought up a term that, we ERISA attorneys like to use a lot, this notion of settler. And I think for a lot of plan sponsors, they'll think about it as a fiduciary or a non-fiduciary role. And what we know from studying fiduciary responsibilities is that your fiduciary responsibility is very much facts and circumstances based. And so we can have an employer in a non-fiduciary role charged with or given the responsibility to amend a plan, for example. We know that's not a fiduciary decision. But the argument, and I'm not saying it's going to win, I tend to agree with your sentiment, Chuck, but the argument from the plaintiffs here is that when the employer provides that type of direction, that employer has a choice and chooses one option over the other, it doesn't matter that you're normally in a settler or a non-fiduciary capacity. When you exercise the discretion, you necessarily did so as a fiduciary, and that's where the breach is.
And either Matthew or Mike, so how do we get rid of that? It may seem obvious, but how do we get rid of making that employer a fiduciary and subject to that, the possibility of having a fiduciary breach with the use of the forfeitures?
Matthew, I think you wanted to comment on that in terms of the plan document.
Yeah, and I think that the advice that I'm providing to clients from a more of a core legal advice perspective is, as long as we tend to agree that the IRS is truly comfortable with forfeitures being used for either to offset expenses or to offset contributions, we want to modify the plan language to the degree we can to hardwire in the requirement that, not the requirement, but language that says use it for this first and use it for that second. And by the way, some employers say, hey, we like to use it for expenses first anyway. Oh, that's great. If that's the case, let's just make sure that the document matches the practice. And I think more than anything, and I'll just, Mike, I'll let you have the last word on this, but there's not one specific way to do this. The best way to get to the right result, though, is have a conversation with your advisor and your record keeper and say, what does our plan say right now? What have we been doing? What do we want to do? And does our language match what we want to do?
Thanks, Matthew. We've got 20 minutes here, so these next two slides I'll be quick, but I think what you should take away as an audience member here is the importance of understanding what language is in your plan document. So we have this other case, and it wasn't a class action litigation. It was a litigation brought by the Department of Labor. And in 2023, late 2023, Cypress Solutions was ordered to pay back $575,000 in plan assets and pay a penalty of $57,000 and change to the Department of Labor. The reason for that is, as Matthew sort of alluded to, these plan document provisions, their plan document did not provide for the use of forfeiture dollars to be used to offset plan expenses. They went ahead and did that. They were subject to a Department of Labor audit. The Department of Labor caught this in its audit and brought this litigation, which to me is somewhat surprising that it came to that. I don't know exactly what Cypress was arguing against the Department of Labor's sort of regulation and ruling here, but they ended up losing in court. So I cannot overemphasize the importance of understanding what's in the terms of those documents.
And
go ahead,
Mike,
Chuck.
just to be clear for everyone, as as Matthew was talking about, these plaintiffs in the class action lawsuits may not win. The argument, frankly, it's a little tenuous. But this case is different. So if you're saying, well, why did this one lose? Because as Mike alluded to, this plan just did not follow their plan document at all. They were not allowed to use it as an employer contribution. It was not a discretionary or decision. It said that they were supposed to pay plan expenses, and instead they used the money for the plan sponsor. So violating the plan document is clearly a breach. And so it's a little bit different than these class action lawsuits that we're seeing right now with this discretion.
Thanks, Chuck, for that clarification. In terms of big picture, I think in some regard, the best way to stay out of the courthouse, at least, regardless of the nuances of this forfeiture litigation, is just to make sure that you're overseeing the plan, make sure that you're having regular reviews, that you have minutes for those reviews, and document your plan's expenses. Make sure that you're not overpaying, because if you're not, then, and if you've got a reasonable expense for your plan, if your investments have a reasonable cost and they're not loaded up with 12B1 fees, et cetera, although that's increasingly rare, more common in the small plan market, you're going to have a pretty good opportunity to negotiate and perhaps get out of a litigation before it even gets to the courthouse. So with that, I think we'll wind up here. We've got a little over 15 minutes left. Matthew, I think you were going to cover some hot topics, and I think on a go-forward basis, I think you will provide something to our clients, because you're really directly in the field now, practicing law and working not just with our clients. So you'll have a perspective that's outside the firm. So with that, I'd like for you to cover some hot topics.
Great. Yeah, thanks, Mike. And I'm going to talk about 5 topics here. The first 4 have an explicit action item for everybody listening. And then the 5th will be, I'm going to actually hand the baton back over to Chuck to talk about some practical implications of a big Supreme Court decision. But as I work through items 1, 2, 3, and 4, I want to start with this first one. And this is just a reminder, and heck, Mike, you just referenced this, that process really matters. And having your process in place, a very buttoned up process, and ensuring that your prime capital retirement team also has that process in place and is following it routinely, will put you in a good position from both a risk mitigation and an outcomes perspective. And so we wanted to highlight the Silva case here to begin with. So this was a case that had gotten past the motion to dismiss. So the plaintiffs filed this lawsuit and said, hey, there's a lot of these normal fiduciary breaches. We had bad investment options. We had excess expenses, didn't negotiate lower record keeping expenses. And the court initially said, we're going to let you get into discovery here. We think there's enough to proceed. So they got into discovery, and after the case or the course of discovery, the fiduciary said, hey, we've been through discovery now. There's really not enough here where we could lose if this even went to trial. And the court agreed. The court said, you've produced enough information supporting the idea that your process is diligent, it's deliberative and rigorous, and it's prudent. So this is a really good reminder, I think, to all of us that even though we can't control exactly what could happen at the motion to dismiss phase, we can indeed be successful at that interim phase of litigation, which is that motion for summary judgment. So ensure that you're having conversations within your committee and with your advisors and saying, do we have in place a consistent process for monitoring our investments? Do we have in place a consistent process for performing the necessary benchmarking? So that would be item 1. Item 2 really gets into this recurring theme that value really matters. And this relates to a suit actually that was just thrown out last week. Very large class action lawsuit brought by participants saying, hey, the fiduciaries breached their responsibilities because we paid excessive record keeping and administrative fees. And the fiduciaries said, hey, court, you should throw this out. And one of the reasons you should throw this out is that we chose a high touch, high service record keeper that provides more services to our employees than other record keepers would. And the court said, that makes sense to us. That's persuasive. In fact, we're pretty comfortable with the idea here that higher expenses are okay if there's more value, if there are more services provided. And you can see a couple of quoted phrases here from the court's ruling, one of which was noting that the record keeper provided services that were not included in the standard and fungible services that all record keepers provide. And in fact, noting that the plan participants may have been charged higher fees for extra services means that the plaintiffs have failed to state a plausible record keeping fee claim. So reminder to all of you listening that if you have chosen a high touch record keeper, a high touch third-party administrator, or if you're receiving a lot of education from your relationship with Prime Capital, for example, you want to document the education that you're receiving. You want to document the additional services that you see from your record keeper. Any way that you can demonstrate the value add would put you in a position to say, hey, there's no fiduciary requirement to buy the cheapest thing. We want to buy the best thing that we can. So just a reminder, document those decisions that would support the notion that value matters and not just low cost. Mike, if you can flip to the next page, item 3 on our list here gets into target date funds. And I know we've talked about this a lot over the last several years, but it's a really, I think we received a ruling from a federal court recently that validates our belief that target date funds merit special scrutiny. So you might remember that back in 2013, the Department of Labor published these tips for ERISA plan fiduciaries that apply to target date funds. And there's been this kind of long and winding road in a lawsuit that was styled Lauderdale versus NFP retirement. There were a whole host of allegations within this lawsuit, but one of the primary allegations related to the customized or the custom built target date funds that were being utilized. And the general argument here was the fiduciaries had breached their responsibility in many ways, the way that they built those, the way that they managed those, the ways that they looked after those target date funds. So they get all the way through discovery, they actually go to trial here. And when the court issues its opinion in support of the fiduciaries, it actually cited to the Department of Labor's target date fund tips. And it noted that those had been constructed and were being managed in a manner that was, quote, consistent with the DOL TDF guidance, end quote. So the action item for you, to the extent you haven't done this recently, at your upcoming meeting with your Prime Capital advisors, ask about the target date deep dive report. You probably know that Prime has developed this proprietary solution for taking a look at your target date funds and memorializing the various aspects that you're looking at. But here's the real kicker within that report. There's a checklist within that report that ties back into the 2013 tips. It actually takes those tips, gives you a checkbox and room for a text to recognize that you've been through that process. So ask your advisor about this. I would do that at your next meeting if you haven't done it any time in the last 3 to 4 quarters. And then the final point here, and I won't belabor this before I get to you, Chuck, the fourth of my 5 items is just really reminding everybody these Secure 2.0 provisions, they're here. Some of them are already here, some of them are coming right around the corner. But when we get into those questions like, hey, what's everybody doing? Like, are more plan sponsors doing this or not doing this? Are they opting in? Are they opting out? To a certain degree, the eventual utilization of the super catch-up, for example, or the utilization of these various distribution triggers or the penalty tax relief, some of that's going to become a little circular or kind of self-fulfilling. And what do I mean by that? Well, many of these record keepers have said, hey, when it comes to the super catch-up, we're going to assume you want that unless you opt out. And when it comes to these other distribution triggers, we're going to assume you don't want those unless you ask for them. Well, we know from automatic enrollment, for example, that there's a big difference in the outcomes if you have opt-in versus opt-out. So I wouldn't get too hung up in what the eventual numbers look like as far as how many employers are doing X and how many employers are doing Y. My recommendation is that you sit down and think about these for your organization and you say, what is available with our record keeper? What do we want to do versus what do we not want to do? And then what is the opt-in versus the opt-out approach that our record keeper has taken? Have those conversations. Some clients are saying, hey, this is a retirement savings plan. Why would we put in all of these extra components that really dilute the ability to save for retirement? And others have said, my gosh, the focal point for our employees has changed. We know they need to save for retirement, but their broader financial wellness depends on them having some additional security, depends on them having access to up to $1,000 for an emergency expense. So we want to give them that option. I'm not here to tell you what you should choose and what you shouldn't choose, but really to think about what that process looks like to make sure you're actually making choices on these rather than just writing whatever default the record keeper has set. And then I promised on my fifth one, I would hand it back over to Chuck. You know, Chuck, we talked a lot, over the last couple of years about the Department of Labor's work to broaden the fiduciary umbrella, to develop a new fiduciary rule, which it called the retirement security rule. We're not talking a lot about that in this webinar because, well, for a couple of reasons. One is it's been put on hold by a couple of federal courts. So we don't quite know what's going to happen with that. But maybe even more broadly, there was a very big US Supreme Court decision that directly impacts the degree of deference that we provide to a regulatory body like the Department of Labor when they come up with a rule or a regulation. And I think you might have some thoughts maybe to share with everybody listening here about what that Supreme Court opinion does, what it doesn't do, and why that might matter to them.
Yeah, thanks, Matthew. What we're dealing with here is there's an old case from 1984. So think back to 40 years ago when it was Carl Lewis and Mary Lou Retton were in the Olympics. There were involving Chevron, in which the Supreme Court set down a rule that basically said when an administrative agency of the United States government interprets a statute, the court will give them deference if there's an ambiguity in that statute. So basically, if the statute is very clear, we're just going to follow the statute. If the statute is ambiguous, we're going to leave this up to the experts, whether it's the Department of Labor, the IRS, or any other regulatory body. They're the experts in this area. We're going to give them deference. We're not going to follow it 100%, but if it's reasonable, we're going to defer to that regulation. So for 40 years, we've kind of operated under this system where, frankly, there wasn't much of a distinction between a statute and a regulation. And oftentimes you hear commentators talking about a regulation when it's actually a statute, or they call it the law when it's actually a regulation, because they were very similar. The IRS and the Department of Labor were basically given that level of authority. But what we had recently, a more conservative Supreme Court, in this case called Loper Bright, basically said, we got it wrong. If there's a statute and it's ambiguous, our job as the judiciary under the Constitution is to interpret that. It's not to defer to the administrative, the executive branch of the government. As the judiciary, we're supposed to interpret that. So really it throws away that 40 years of regulatory authority, the hierarchy of where regulation stood, and moves that back into the judicial sphere. So Matthew, you alluded to the fiduciary rule, but it's far more than that. Just in the retirement plan space, the ESG rule, which if you recall, basically permitted, the Department of Labor said, if there's a tie between two mutual funds and one of them is ESG and one is not, we'll let you pick the one with ESG. Well, that's not anywhere in a statute. That's the regulation saying that. So a court could come in and say, you know what, you don't have the authority to make that a law. That's your opinion, and we'll give it some level of authority. It's really amorphous on what that level. It's almost like just listening to the Department of Labor as though they're another expert, but they're not given them deference. We alluded in Mike's section to forfeitures, and we had that regulation from the IRS saying what it can be used for. Well, what if the judicial branch says, you know what, that's your opinion, we're going to take that under advisement, but our opinion is the statute is very clear that it needs to be interpreted this way. So it kind of throws the world into a little bit of chaos as far as what level of authority regulations from the IRS and the Department of Labor are going to carry. At the same time, like the very next week, they also issued an opinion called Corner Post, which basically said under the Administrative Procedures Act, there's a 6-year statute of limitations. And that has always been interpreted that a lawsuit alleging, that the regulation was unconstitutional or improper had to be brought within 6 years of the regulation being finalized and effective. Well, this court said, no, it's 6 years from the date that it impacts or creates damages for a person or a corporation. And so basically it eliminates the statute of limitations for anyone opposing a regulations or challenging a regulation. So there could be statutes, and just think of a new entity that is just wholly created, even though there's a regulation that's been out for 20 years and that company was fully aware of that regulation when they were incorporated and started doing business. They could allege, well, it's just impacting me now for the first time, so I'm going to challenge this lawsuit or challenge this regulation. And under this new guidance, it's possible that they're not going to give deference to the regulatory body. So it really puts the whole world into chaos. I will put one other thing that we're dealing with is if the statute, going back to the Loper-Bright Chevron, if the Congress gives authority to the regulatory agency to enact regulations, then they will continue to get some level of deference. And so right now, people are trying to figure out what's going on. In ERISA, there is some level of authority that Congress gave when this law was passed 50 years ago, back in 1974, to the Department of Labor and the IRS, but that will have to get flushed out exactly what level of authority that they delegated to the Department of Labor and the IRS to figure out exactly what deference the courts are going to give to those bodies. So put a pin in this. We're going to hear a lot more about this over the next year to 5 years to kind of figure this out. But it is definitely a talking point when you're at your next cocktail party to bring up Chevron or Loper-Bright. So with that, Mike, I'll turn it back over to you to wrap things up.
Chuck, I'm trying to not laugh too much here relative to, it depends upon your audience on the cocktail party there. You might have some
My cocktail parties, they're a hoot, I'll tell you.
Many cocktail parties, just saying you're an ERISA attorney is enough, but I digress. In any event, Scott, thank you for joining and sharing the update on Secure 2.0. Chuck, your perspective on the catch-ups and the discussion here about Chevron, and especially Matthew for joining us with your perspective, your broad perspective across the industry. We'll do this again next quarter. If anyone has any questions, you should receive a follow-up email. We'll be more than happy to answer those directly. And if you have a good contact for your Prime Capital retirement advisor and have some questions, please feel free to follow up with them. With that, we'll end timely, and I'll thank everyone again for joining today.